Okay, so the gentlemen accused of the Manchester airport assault were finally produced in court last week for a whole 9 minutes. So what was going on there, and why, behind the scenes, were the prosecution and defence getting their heads together? What was going on? Well, hopefully that sounds suitably clickbaity and intriguing, but actually it's an excuse to talk about some of the more technical sort of things and procedural things we have to do, because I know you sort of quite like these behind the scenes things. And I mean, Dan's done a rather excellent video where he's explained that this was what we call a pleas and trial preparation hearing, and even though there was only 9 minutes of court time, there is a lot of work behind the scenes to prepare for this. So what I thought I'd do is I would take you through this form, which hopefully, thanks to Dan very kindly recorded this scrolling for me. But this is something called a plea and trial preparation hearing, parties pre-hearing information form. And it's where you set out, as the name suggests, all the things to prepare for trial. Now, back in my criminal law days, we call these PDHs, pleas and directions hearing, and again there was a form, but it was a lot simpler. Although it covered more or less the same ground, you know, who are the parties, how long do you estimate the trial to be, and all that sort of thing. But it's a lot more complicated now. So what I thought I would do is, well, that's close scrolling away. I'll keep talking because I'm just watching it on a little video monitor I've got here. I've just thought I'd sort of just take you through it, just to show you the sort of information that you need to submit to the court. So, in practical terms, what happens? Well, the hearing will be listed. And like I say, this is a pleas and trial preparation hearing. And as the name suggests, normally you would put your plea in, guilty, not guilty. And if it's a not guilty plea, then there needs to be a trial. And this is where you set out exactly, you know, what is needed there, so how long it's going to be, what witnesses, what disclosure, and how, you know, all that sort of thing. I mean, if somebody was to plead guilty, then obviously this all becomes a nullity, and you just set something down for sentencing. You might say, well, they can plead today. I mean, just to be technical, when you put the plea in, that's what we call arraignment, and that's the official start of everything. Obviously, all cases start off in the magistrate's court, and then if they're serious offences, or the defendants elect jury trial, even if the magistrates say they can deal with it, you give an indication of plea, but that's not actually putting in a formal plea. So this is the first time you formally plead guilty or not guilty. Sometimes actually you might give a no indication, and then things will proceed, because it might be you're waiting for information before finally deciding. But generally speaking, this is the procedure when it's a not guilty plea and you know it's going to trial. So you will arrive at court and you will go and sit in the bar mess or the robing room. I mean, sometimes you sit in the canteen, but then you get into all sort of GDPR issues. But the prosecution and defence will get their heads together, because this is meant to be a collaborative exercise. Because ideally, you put in one form. I mean, you have to pretty much put in one form now. There might be areas of disagreement as to, you know, is this disclosure really necessary, or is this timetable? Then you might say, well, we'll let the judge decide on that. But normally you would sit down and you'd do this form together. So let's go through it. I won't go through everything in all detail, but I hope you can understand why, even though there's only sort of like the actual hearing's only a few minutes. Because it's, you know, enter the plea, have we got the forms, let's go through the forms, judge just checks everything and signs off on it. And like I say, sometimes there might be just a little bit, oh, you know, when do we select, you know, what date should we allow for this and all that sort of thing. But here you go, here is the form. So, you put in the court, you know, where everything's happening. The next number is the T number. That's the actual case reference number. They're all sort of like T something 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 something, or if it was for sentencing, it would be S something something something. But there's also the URN. That's the unique reference number. That's the reference number that the case is first assigned at the magistrate's court. So you've got, you know, typical efficiencies of the criminal justice system. You've actually got two reference numbers. But once it gets to Crown Court, everything is listed under the T number. So if you go to, there's a thing called Court Serve where you can check court listings, and you'll see that everything is listed by reference to that number. You put in who the defendant or defendants are, their date of birth, because obviously if they're under 18, then different procedures apply. The principal charges, there's not a lot of room there, but you could put something, like, you don't need to go all the details, so you might say something like theft or the M word or common assault, something like that. The remand status, are they on unconditional bail, conditional bail? Are they actually remanded in, prison? Or are they being detained as a youth in youth custody? Also something called the custody time limit. Theoretically, you could only be held on remand in prison for 112 days. After which time it's like, well, normally either have the trial or release them. Now, as we know, trials take years to come on. And obviously, it's like, well, if somebody's been remanded for good reasons, you're not be basically kept in custody if there is a realistic ground to fear that it may be failing to attend trial, interfere with witnesses, or otherwise pervert the course of justice, or commit further offences. So theoretically, if you're inside, there's a good reason for keeping you inside, but you can't stay inside forever. In practice, though, you can extend the custody time limits. And that happens a lot now, just because we can't get trials on quick enough. So there'll be a hearing where you go along, the prosecution say, we need to apply to extend the custody time limits, and the defence can either object, or usually, to be perfectly frank, we go, no representations. I mean, still leave it open to the judge to say, no, he should be released. But generally speaking, if you say, no, he should be released, it's not fair. They say, well, it's not really safe to let the person out. This goes back to what we've discussed before about people staying on remand for years. And then if they're acquitted, it's like, well, you've been banged up for 2 years. Or you get convicted and you get a sentence that's less than the time they were actually remanded in custody. And, there is this argument that is putting on pressure on people to plead guilty, even when they're not. Because it's like, well, if I plead guilty, I'm going to get a 1 year sentence. I'll actually serve 6 months. If I plead not guilty, I'll probably actually stay in prison for 18 months or 2 years. It's a bit of a no-brainer, really. And also the date of sending. Just to sort of make this hopefully slightly more interesting and less robotic, my first ever appearance in court on my feet after I got my practice certificate in my what we call second six. When you do pupillage, it's a 12 months effectively like an apprenticeship, although I have to stop calling it an apprenticeship because now we are looking at introducing proper apprenticeships at the bar. And I might have a video on that coming up with the wonderful Bar Standards Board. They're going to come on and explain how it works. But for the first 6 months, you just have to tag along and follow other barristers and see what they do. But after your first six, in what we call your second six, you get a provisional practice certificate. It's like having a provisional driving licence, and it's effectively, yes, you can now do things in court on your own. And the weird thing is, it's like at any level. I mean, normally they just send you to the magistrate's court or something like that, but theoretically you could do, you do Crown Court trials, you could do Court of Appeal stuff, you could go to the Supreme Court. And my first ever one was an application to extend custody time limits. We were acting for the defence, and it was quite a serious case. It was an M-word case at the Bailey. And it was my head of chambers and my pupil master. They were sort of like leading counsel and junior counsel on that trial, but neither of them could be bothered just going across for an uncontested custody time limits thing. So I was told, like, okay, all you got to do is go along, prosecution will say, we apply to extend the limits, and you just say no representations or something like that. Don't consent to it, but just sort of say we're not raising any objections. And I was going, oh, I'm not really sure about this. I mean, this is an M word at the Bailey. Should this really be my first appearance? At which point my pupil master, who was very blunt, just turned around and said, oh, for heck's sake, Robertshaw, what's the worst that can happen? You make a total beep of it and they'd release him. So I suppose, that was a good point. That's all to do with, like how long people are kept in prison. But we then move on. The next section is just everybody's contact details. Who's dealing with it at the court? The case progression officer, that's the person you would contact to say, can we have a listing, or, we need a mention or something like this, or we need another hearing, or we need to see the judge. All the prosecution contacts, the advocate at the actual hearing, who might not be the trial advocate. And then you put the trial advocate, who's the reviewing lawyer at the CPS, who's the progressing lawyer at the CPS, although as it always says, usually paralegal. In other words, somebody who is not necessarily qualified, but perhaps on their way to qualifying, and a lot of paralegals, actually most paralegals I know, probably know more about things than the supposedly qualified lawyers. Also the officer in the case, that's the poor old police officer, who is the one who is, you're in charge of this case, and you're the one who's going to get shouted at by the judge if the police, don't get their act together. Same for the defence contacts, who are the defence solicitors, if they have solicitors, if they're unrepresented, what's your sort of personal details. And again, you should have a case progression officer, somebody at the solicitors you can identify and say you're the person who we should be contacting. And again, advocate at the hearing, advocate at the trial. You also tick how things are being funded. The next thing is just a list of information that should be available at the pleas and trial preparation hearing. Obviously a draft indictment, because the indictment is the document that sets out what you are accused of. And it sets out a statement of the offence and then particulars of the offence. The statement of the offence is, the legal definition. So it could be something like N-word against common law. More often it's something statutory. So theft, contrary to Section 1 of the Theft Act 1968. Because obviously if you're going to plead, you need to know what you're pleading to. And I've done a previous video, which I'll let you search for, about Newton hearings and agreed basis of plea and everything. Because, another thing you might be doing is sitting down in the canteen or the bar mess, just sat there going, well, okay, would you take a plea to X? If you drop that one, he'll plead to that one. Or if you call it an ABH rather than a GBH, maybe we can, make some progress today. Summary of the circumstances of the offence, all the statements, sort of initial CCTV, all that sort of thing. And you just say, is it available? Yes or no. Sometimes it's not applicable, there's no CCTV. And if it's not available, when can it be served by? So you sort of say, we could probably get this done. So, we're waiting for an expert's report. We can probably get it done by this date, that sort of thing. And then you sort of defence information. How long do you think the trial's going to last? 1 day, 3 days, 4 weeks, whatever. The weird thing is, it actually says to include jury retirement. It's like, so we've got to guess how long the jury's going to be out. Well, I think my closing speech is going to be so good, they're going to acquit him in minutes. So 15 minutes. Interestingly, when it comes to returning verdicts, you may have heard of majority verdicts, because generally speaking, a verdict has to be unanimous, 12-0. So either way. Now, if you lose jurors, through illness or whatever, it could be 11-0, 10-0. You can actually go down to 9 jurors, but then it must be a unanimous verdict. It must be 9-0. But if people can't agree, then they will accept a majority verdict, which is either 10-2 or 10-1 if there's only 11 jurors, that sort of thing. But you have to give the jury time to sort of try and thrash things out. And the time limit is you've got to wait at least 2 hours and 10 minutes before you can say, okay, you're clearly stuck on this, I'll accept a majority verdict. And the idea is you give them 2 hours to actually discuss things, and the 10 minutes is because it's going to take them 5 minutes to go to the jury room and 5 minutes to walk back. So that's where we get those sort of figures from. What I quite like is that there's then the category that says real issues, defence to summarise so far as known the real issues in the case. So forget all the nonsense stuff you're going to raise and all the sort of peripheral defences and things. What are we actually arguing about this? Is this just who threw the first punch or something like that? Or is this the issue, yes, he was there, but he wasn't involved? Just crystallise down to sort of that nub of things. Because this is the thing, you pretty much have to disclose both parties, the prosecution and the defence. It's all cards on the table. It's almost like civil litigation. There's no surprises. There's no ambushing of people. Oh, well, who would have, here's my series of witnesses, my surprise witnesses, each more surprising than the last. And then he puts things like, was the defendant under 18 when they were sent to court? Because again, that can have different implications. Is it a vulnerable defendant? Are they said to be a victim of modern slavery? Then there's things about forensic reports. Can we just agree to streamline do we need all the full forensic reports, or is it something where we'd accept just a summary because it's not really in dispute, something like that? Then it's all things like, what other things will you be serving? Do you agree that, because you can sort of say, if you put in a defence case statement, which you have to do at a Crown Court, and that literally sets out what your defence is. If you don't provide one, then that can, first of all, draw adverse inferences. Well, he's waited till trial to sort of say what his defence is. You may, members of the jury, think that's just because he's just waiting to hear the evidence and then make something up. But also, you don't get what we call secondary disclosure unless you put a defence case statement in. So the prosecution give you all those initial documents. Here's what we say is enough to convict you. And here's some unused material that we're not relying on, but we can see why you might want to see it. Because you have to disclose any information that may assist the defence or undermine the prosecution case. But unless you put a defence case statement in, you don't get secondary disclosure. So you can sort of say, well, our defence is... we have an alibi. We were playing pool all day when this offence was meant to have taken. So we want the police to go to the pool hall and, get the CCTV and take some witness statements from people down there and all that sort of thing. So you suggest lines of inquiry for the police to follow up on. And you can sort of, you sort of say, we think this is a reasonable line of inquiry. Sometimes the prosecution will agree, sometimes they won't. And if they don't, that's the sort of thing at the hearing where you'd say to the judge, what do you reckon, their obligations should be? There's also issues about, third-party disclosure, all that sort of thing. You can do applications also for, are you going to apply to dismiss the case and say, well, we say there's actually not enough evidence for even a prima facie case. So before we get to trial, we're going to come along and say, even if you believe everything the prosecution say and they can prove it, that's still not enough. Because the test is, on the evidence available, could a properly directed jury convict on just what's there? And sometimes you might say, well, no, with all the information here, I don't think a jury could lawfully convict. So you can have an argument about that. Are there any other preliminary issues that need to be discussed? Are you going to apply to sever the indictment? You might have either an indictment where a number of people are charged with the same offence, and it might be, well, we think there should be separate trials for, whatever reason. Or it might be, I am charged with a number of offences, but I think you should have different trials for each offence because, try me on that at the same time as that might prejudice the trial because they'll say, well, if he's guilty of that, he must be clearly guilty of that, and actually the amount of evidence is all different between the two. Can they actually be arraigned at the plea? Are we ready to say, are you guilty or not guilty? Judges get really annoyed if you're not ready. An alternative pleas. The defence can say, we've said to the CPS, we're willing to plead to ABH, just not GBH. And you can actually put that down there. And it's not considered to be an admission, by the way. It's like, on the form, they say they must have at least done the ABH. And then there's a little bit of guidance as to how to fill out the form. But then it's just practical things like, what witnesses are needed. So you list all the prosecution witnesses. What dates would you need them there? Is there any disputes about, whether they can give evidence or what evidence they're going to produce? So you set all that sort of thing out. Do you need people got intermediaries? That's if you've got vulnerable witnesses. Do you need somebody to come along and stand, in the witness box with them? It could be just something like they need a sign language interpreter or an interpreter, something like that. But it might be, well, they're a vulnerable witness. They just need somebody there to, support them emotionally or all that sort of thing. If it's young or vulnerable defendants or witnesses, do you need special measures there? Should we not be wearing the fancy dress? Do we need video screens for people? Are people going to give evidence by video link? Are they going to be pre-recorded? Then there's a list of, this might be interesting to people, with all the free speech stuff. What can people report about the case? Do there need to be any reporting restrictions there? If it's somebody under 18, there's an automatic, you can't name them unless the judge says otherwise. But also people can, argue and say, I've got a witness who's, needs to be anonymous because they're worried about reprisals or something like that. This is the sort of thing you'd set out there. Also, you sort of said, do you need a ground rules hearing? If you've got vulnerable witnesses, the way you approach and cross-examine vulnerable witnesses, what's permissible is very different to just the general free-for-all. Although I always argue, actually, that because I'm a very sort of gentle cross-examiner, that actually there's not a lot of difference between how you would examine somebody, a regular witness, and how you'd examine a vulnerable witness. But the ground rules hearing is where you sit with the judge and say, right, we've got a vulnerable witness. And the judge will say, right, here's how far you can go. Some judges will say, I want you to write out all your questions, and I'll approve them. Other judges might just say, here's a list of topics you can talk about, here's a list of topics I don't want you to stray in. Other judges might just say, look, you've been doing this for years, I trust you. And that's the ground rules hearing. Then you look at things like video links, all that sort of thing. Please, if people put in pleas, you need to sort of make sure that you know what they're pleading to. So it's sort of, I love it. It says confirm which version of indictment being pursued if more than one. Because sometimes you might have draft indictments and then it's like, well, change that, and you'll get a second version of it. It might have a different offence on or a different description of the particulars of the offence. So obviously somebody's going to plead, because obviously that affects sentencing. You need to make sure that everybody's, on the same page of the hymn sheet, as it were. And it has boxes, the defence have to confirm we've sat down and explained to our client, about, it's a free and voluntary choice if they're pleading guilty and what the consequences are and all that sort of thing. If they go not guilty, the judge has to give them a little direction saying, look, you'll get a discount if you plead early, by the way. And the judge actually says that, putting no pressure on whatsoever, but judge explained the allegation and gave warning to defendant on credit for plea. So you put that there, and you'll just put in what people pleaded to, because it might be they plead guilty to count 1 but not guilty to count 2, that sort of thing. So this is just a record, and then you try and set a trial date, and there are different ways of setting trials. I mean, the best way is a fixture, where they say the trial will start on this specific date at this specific time. But that's actually quite rare because of just how courts work and courtroom availability. So it's almost a bit like airlines. They overbook and then hope that not everybody will will be ready on the day. So you might list 3 or 4 trials on a day and go, well, yeah, because if somebody turns up and then the classic one of, well, we've turned up now, all the prosecution witnesses are here, all right, I'll plead guilty then. All of a sudden, a courtroom is free for however many days a trial was listed for. And you don't want that courtroom not being used, so you'll have people on standby. And that's what we call a backer, where it's a trial that's waiting. You're just behind the sort of star billing people, but if their trial doesn't go ahead on the day, you get their slot. And then you have what we call floaters, which is basically at some stage in this 2-week period, your trial will get called on. We'll let you know at 4 o'clock the day before. So please keep that clear out of your diary. Sometimes you have fixed floaters, which is if you come along, we're not exactly sure when your trial's going to start. If you turn up on that day, we'll definitely try and get you on. And like I say, and sometimes you have a warned list. It's like a warned list. The trial is warned for this period. It might take place sometime in this 2-week period, so be on standby, but we're not guaranteeing anything. And then you, 28 days before any date listed for trial, you have to put a certificate of readiness, just saying, yep, we're ready to rock and roll. And if not, you have to let the judge know and say, actually, we might not be ready on that day, because, then the judge knows to shout at you. And then there's just a further list of, things that each side have to do and what dates they have to be done by. So it can be things like serve transcripts of interviews, serve the 999 call recording, all that sort of thing. The stuff that you don't get on the first, at this hearing, because it might not be ready yet. Or they might not have prepared it, because a lot of the time they go, well, if he's going to plead guilty, there's no point doing all this work. So we'll wait until they definitely go not guilty before doing it. And, it's things like serving witness statements and all that sort of thing. You might need to instruct an expert. And you just put all the times down there. And then it's things like third-party disclosures. And, the judge will say when all this needs to be done by. Then you sort of go through all that. And that is pretty much it. So basically, like I say, I'll just put some of these up so you can sort of see the sort of things that need to be done. It might be that with a vulnerable witness, like a child witness, we're going to do it by pre-recorded interview. So do the interview by this stage and provide the tape of the interview to the defence by this stage. All that sort of thing. So you go through all that. The judge will make any other orders that they might need. Do you need a witness summons if somebody's reluctant to attend? The judge will then give final judicial warnings that a failure to provide a sufficiently detailed defence statement may count against the defendant. The failure to attend when required, whether from custody or bail, may be a separate offence. At the trial, you can give evidence, and if you fail to attend, then we might have the trial without you, all that sort of thing. And they can put any other warnings that they want to do. The judge lists any other directions that are necessary, and then once it's all done and we're all happy with it, or at least we're basically going, well, the judge just said this, so we're going to have to live with it, we all sign it and the judge signs it, and that goes on. There's a digital case management system where everything's uploaded electronically now, generally, all the witness statements, all the material, it's all on held on the cloud, and you've got access to that. So you can just get the documents electronically, and this form will actually go on the digital case management system in case anybody needs to look back at it and go, oh, when were we supposed to do that by? So that's pretty much it. So that is why you've probably seen this is quite a lengthy document. So you can probably see why it does take a couple of hours to go through it. I mean, sometimes you might have sort of turned up at the court, you'll have filled all your bits out, the prosecution will have filled yours bit out, and then it'll just be, shall we, fill it, just complete one of the forms. And when I used to do the PTPH form, sometimes we'd basically say, here's 2 forms we've done, Judge, but if you read them together, we've covered all the bits. And then sometimes judges will say, that's fine. And other times judges will say, oh, stop being lazy, go back in there and just bring it to me on one form. So that's what you all have to do. And how much do you get for all this? Because like I say, okay, the hearing might be only minutes long in court, but you've done all this work. How much do you get paid for it? Well, here's the fees. If you are a Queen's Counsel, a silk, you get, and this is, because I'm using the Manchester one as the example, so this is where you've got more than one defendant, because you get a slight uplift if there's more than one defendant, because obviously you've got more work to do in terms of identifying witnesses and evidence and things like that. So if you're a Queen's Counsel and you attend the hearing, which is quite unusual usually, because if you've got like a Queen's Counsel and what we call a junior, sort of 2 people, they'll say just send the junior to the pleas and directions hearing, sorry, PTPH. But if the QC, KC attends, they will get £253. If it's a leading junior, because that's where they say, okay, we think you can have 2 counsel for this case, because it's quite a big, complicated one, but we're not springing for a silk, so it can just be 2 juniors, and you decide between yourself who's in charge. You get £192, but if it's just your bog standard sort of case where it's 1 junior barrister, that's all you're getting, that's all legal aid's springing for, you get £126. So there you go. So work out, you got to pay your own travel to court, you got to pay your own parking, knock off the tax, knock off all that sort of thing. But yeah, it's £126 is your gross fee for this. Of course, you don't receive this until the conclusion of all proceedings. So it's like, we owe you £126. When this trial is concluded in 2 years' time, you can put in your, we're called graduated fees form, where you sort of say, this is all the work I did, and this is how long the trial lasted, and this is how much material I had to read. You send that off to the Legal Services Commission or Legal Aid Board, whatever they call this week, and in a 9 months' time or something, they will come back and say, well, this is how much we are going to give you. It's really annoying that, because they would always knock you down on your, you put in the form saying this is how much it should be. And it's all fixed fees, it's not difficult. It's like, if there's this many pages, it's this. If there's this hearing, it's this. But they will always come back and sort of go, well, we're knocking you down a bit. And you say, well, hang on. I did all this work. But the deal is, if you want to challenge it, you can't cash the cheque. It's like, oh, well, if you want to appeal this, don't cash the cheque, and we'll put in your appeal and we'll address that in the next year or 2. But if you go, you know what, I'm just going to put the cheque in, you're deemed to have accepted this. And this got really bad, because we would actually get the judge or the judge's clerk to sign the graduated fees form at the end of the trial. Yes, they were here for this many days, there were this many witnesses, there was this amount of material. And they would still go, we're not accepting it. I mean, one of my friends, she had a real row because the Legal Aid Board refused to accept. They said there's no evidence you were actually at court for some of these days. And she goes, like, it's literally signed off by the judge, saying I was there for like 9 days. And they go, oh, we think you were only there for 5 days, prove you were there. So that's why, I say we keep losing people at the criminal bar, because we've just been messed around by the Legal Services Commission. But there you go. Like I say, a very behind the scenes thing. Sorry to ramble on for so long, but I just think it's quite an interesting subject, and it shows you how much of things go on behind the scenes, and how the defence and the prosecution have to cooperate. But yeah, as always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. And we have a new member of our little gang. This was sent to me by a very lovely person, along with lots of other nice, cute things. But yeah, so Lord Loverduck and Cappy Barrister have a new friend. And we're looking for suggestions for names, because he's obviously a detective duck. Some people have suggested Sexton Drake, which I quite like. But yeah, if any of you got any brilliant ideas, let me know. And I haven't tested whether you squeak. Yeah, more or less. Well, you might be a bit wheezy because you've got a pipe.